Hi everybody, this is attorney Shah Peerally for a discussion about change of status versus adjustment of status. We oftentimes get the questions, people are confused about the two terms and what it entails. First of all, a change of status is when you're moving from a non-immigrant status to another non-immigrant status. For example, you come on a visitor visa, which is a B2 visa, or a B1 visa, which is the business visa, and sometimes a combination of B1, B2, and you want to move to an F1 visa. That's a change of status. And or you want to move to a TN visa or an O visa. Those are changes of status. And what it does for a change of status, in order for you to change status, you have to be in status. You cannot be in a pending status, I repeat that, but you have to be in a solid status. For example, before your B1 expires, if you file on timely, you file what we call an F1, you will be able to, probably if it gets approved, to change status to the F1. But this has to be done, it has to be filed and reach the USCIS before your status is expired. And your status is what is on the I-94 usually, and the I-94 is what you get at the port of entry. For example, you have a 10-year multiple entry B1 B2 visa, but at the port of entry they give you only 3 months or only 6 months, and that's what controls when you are inside the United States. And before that, you need to do the change of status. However, for adjustment of status, the rules are very different. When you're doing an adjustment of status, that means you're moving from a non-immigrant to an immigrant visa. That means you're moving to a green card. And what it does, whenever you file it, the green card is pending. It creates what we call a period of authorized stay by the Attorney General. That means you're legal in the United States until the green card comes. But it is not a status. And the same rule will apply also if you're filing for a change of status. There's a period of stay, but you will, once it gets approved, you will move to another status. But on the green card, you don't move any status, you move straight to the green card, which is a permanent residence. The difference for when it comes to change of status to adjustment of status, for change of status, you have to be in status in order to move to another status. As for adjustment of status, there are exceptions to that rule. Although in most cases you have to be in status, for example, employment-based visas, you have to be in status in order to move to an adjustment of status. However, there are exceptions. For example, one of the exceptions is the Life Act, the INA 245I. If a case was filed for you prior, a genuine and non-frivolous case was filed prior to April 1st, 2001 or 1998, you can benefit. Even you fall out of status, you will be able to file what we call an adjustment of status. But also, if you're married to a US citizen, for example, you enter a visitor visa, and then your visitor visa I-94 expires, and 2 years later you get married, even you're out of status, you will be able to adjust status. The same will apply to VAWA cases. However, if you're marrying an LPR, which is a legal permanent residence, if you are not in status, you will not be eligible to file for adjustment of status until that LPR is legal permanent resident, until that person becomes a citizen, or ultimately you benefit from the Life Act, which is INA 245I, or also there is a VAWA situation. So you need to be very careful, because the confusion of the terms ultimately determine what you can file or not file. So be very careful. If you want to change status, make sure you do it before the status expires itself. And for adjustment of status, it's always recommended to also do the same. For example, if you are filing an EB1 and it's available currently for you, and you want to file for the adjustment of status, you need to file this before your status is out. So make sure that you comply with all this. And as for the status side, if you lose it, you might have, for example, let's say you're an H1B, you're filing for an extension of status, and your H1B you get laid off from your job. You might have to leave the country and come back to get back in status, then do your change of status, or you might want to leave and come back on a different visa. So all these are very, very important. You don't want to miss any of those of those deadlines to file your cases. And if you need any help when it comes to immigration, whether it is a non-immigrant visa like H-1B, an L-1, O visa, P visa, you name it, R visa, we can help. And if you need help also with the green card, whether family petitions, marriage petitions, green card to employment, labor certification, EB1, national interest waiver, feel free to call us 510-742-5887. Anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Good luck to you. Thank you so much.